A resolution appointing and authorizing impeachment managers for the impeachment trial of Alejandro Nicholas Mayorkas, Secretary of Homeland Security.
The message will be received and the Senate takes notice of the action by the House.
Madam President and members of the Senate, I announce the presence of managers on the part of the House of Representatives to conduct proceedings on behalf of the House concerning the impeachment of Alejandro Nicholas Mayorkas, Secretary of Homeland Security.
The managers on the part of the House will be received and escorted to the well of the Senate. The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the House of Representatives is exhibiting to the Senate of the United States articles of impeachment against Alejandro Nicholas Mayorkas, Secretary of Homeland Security.
The managers on the part of the House will proceed.
Mr. President, the managers on the part of the House of Representatives are present and ready to present the articles of impeachment, which have been preferred by the House of Representatives against Alejandro Nicolas Mayorkas, Secretary of the Department of Homeland Security. The House adopted the following resolution, which will, with permission of the Senate, I will read House Resolution 995. Resolved that Mr. Green of Tennessee, Mr. McCall, Mr. Biggs, Mr. Higgins of Louisiana, Mr. Klein, Mr. Guest, Mr. Garbarino, Ms. Green of Georgia, Mr. Pfluger, Ms. Hageman, and Ms. Lee of Florida are appointed managers to conduct the impeachment trial against Alejandro Nicolas Mayorkas, Secretary of Homeland Security, that a message be sent to the Senate to inform the Senate of these appointments, and that the managers so appointed may, in connection with the preparation and the conduct of the trial, exhibit the articles of impeachment to the Senate and take all necessary actions, which may include the following. 1. Employing legal, clerical, and other necessary assistance, and incurring such other expenses as may be necessary to be paid from amounts available to the Committee on Homeland Security under applicable expense resolutions or for the applicable amounts of the House of Representatives. 2, sending for persons and papers and filing with the Secretary of the Senate on the part of the House of Representatives any pleadings in conjunction with or subsequent to the exhibition of the articles of impeachment that the managers consider necessary. With the permission of the Senate, I will now read the articles of impeachment. House Resolution 863. Resolved that Alejandro Nicolas Mayorkas, Secretary of Homeland Security of the United States of America, is impeached for high crimes and misdemeanors, and that the following articles of impeachment be exhibited to the United States Senate. Articles of impeachment exhibited by the House of Representatives of the United States of America in the name of itself and the people of the United States of America against Alejandro N. Mayorkas, Secretary of Homeland Security of the United States of America, in maintenance and support of its impeachment against him for high crimes and misdemeanors. Article 1. Willful and systemic refusal to comply with the law. The Constitution provides that the House of Representatives, quote, shall have the sole power of impeachment, end quote, and that civil officers of the United States, including the Secretary of Homeland Security, quote, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors, end quote. In his conduct while Secretary of Homeland Security, Alejandro N. Mayorkas, in violation of his oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, to bear true faith and allegiance to the same, and to well and faithfully discharge the duties of his office, has willfully and systemically refused to comply with the federal immigration laws in that. Throughout his tenure as Secretary of Homeland Security, Alejandro N. Mayorkas has repeatedly violated laws enacted by Congress regarding immigration and border security. In large part because of his unlawful conduct, millions of aliens have illegally entered the United States on an annual basis, with many unlawfully remaining in the United States. His refusal to obey the law is not only an offense against the separation of powers in the Constitution of the United States, it also threatens our national security and has had a dire impact on communities across the country. Despite clear evidence that his willful and systemic refusal to comply with the law has significantly contributed to unprecedented levels of illegal immigrants entrance, the increased control of the southwest border by drug cartels, and the imposition of enormous costs on states and localities affected by the influx of aliens, Alejandro N. Mayorkas has continued in his refusal to comply with the law and thereby acted to the grave detriment of the interests of the United States. Alejandro N. Mayorkas engaged in this scheme or course of conduct through the following means. 1. Alejandro N. Mayorkas willfully refused to comply with the detention mandate set forth in Section 235B2A of the Immigration and Nationality Act, requiring that all applicants for admission who are, quote, not clearly and beyond a doubt entitled to be admitted shall be detained for a removal proceeding, end quote. Instead of complying with this requirement, Alejandro N. Mayorkas implemented a catch and release scheme whereby such aliens were unlawfully released even without effective mechanisms to ensure appearance before the immigration courts for removal proceedings or to ensure removal in the case of aliens ordered removed. 2. Alejandro N. Mayorkas willfully refused to comply with the detention mandate set forth in Section 235B1B2 of such act, requiring that an alien who is placed into expedited removal proceedings and determined to have a credible fear of persecution, quote, shall be detained for further consideration of the application for asylum, end quote. Instead of complying with this requirement, Alejandro N. Mayorkas implemented a catch and release scheme whereby such aliens were unlawfully released, even without effective mechanisms to ensure appearances before the immigration courts for removal proceedings or to ensure removal in the case of aliens ordered removed. 3. Alejandro N. Mayorkas willfully refused to comply with the detention set forth in Section 235B1B3-4 of such act, requiring that an alien who is placed into expedited removal proceedings and determined not to have a credible fear of persecution, quote, shall be detained until removed, end quote. Instead of complying with this requirement, Alejandro N. Mayorkas has implemented a catch and release scheme whereby such aliens are unlawfully released, even without effective mechanisms to ensure appearance before the immigration courts for removal proceedings or to ensure removal in the case of aliens ordered removed. 4. Alejandro N. Mayorkas willfully refused to comply with the detention mandate set forth in Section 236C of such act, requiring that a criminal alien who is inadmissible or deportable on certain criminal and terrorism-related grounds, quote, shall be taken into custody, end quote, when the alien is released from law enforcement custody. Instead of complying with this requirement, Alejandro N. Mayorkas issued, quote, guidelines for the enforcement of civil immigration laws, end quote, which instructs Department of Homeland Security, hereinafter referred to as DHS, officials that the, quote, fact an individual is a removable non-citizen should not alone be the basis of an enforcement action against them, end quote. And that DHS, quote, personnel should not rely on the fact of conviction alone, end quote, even with respect to aliens subject to mandatory arrest and detention pursuant to Section 236C of such act, to take them into custody. In Texas versus the United States, 40 F 4th 205, 2022, the United States Court of Appeals for the Fifth Circuit concluded that these guidelines had, quote, every indication of being a general policy that is so extreme as to amount to an abdication of statutory responsibility, end quote. And that is, quote, replacement of Congress's statutory mandates with concerns of equity and race is extra-legal and plainly outside the bounds of the power conferred by the INA, end quote. Number 5, Alejandro N. Mayorkas willfully refused to comply with the detention mandate set forth in Section 241A2 of such act, requiring that an alien ordered removed, quote, shall be detained, quote, during, quote, the removal period, end quote. Instead of complying with this mandate, Alejandro N. Mayorkas issued, quote, guidelines for the enforcement of civil immigration laws, end quote, which instructs DHS officials that the, quote, fact an individual is removable non-citizen should not alone be the basis of an enforcement action against them, end quote, and that DHS, quote, personnel should not rely on the fact of conviction alone, end quote, even with respect to aliens subject to mandatory detention and removal pursuant to Section 241A of such act. 6, Alejandro N. Mayorkas willfully exceeded his parole authority set forth in Section 212D5A of such act that permits parole to be granted, quote, only on a case-by-case basis, end quote, temporarily and, quote, for urgent humanitarian reasons or significant public benefit, end quote, in that, A, Alejandro N. Mayorkas paroled aliens en masse in order to release them from mandatory detention, despite the fact that, as the United States Court of Appeals for the Fifth Circuit concluded in Texas versus Biden, 20F 4th 928, 2021, quote, paroling every alien DHS cannot detain is the opposite of the case-by-case basis determinations required by law, end quote. And, quote, DHS's pretended power to parole aliens while ignoring the limitations Congress imposed on the parole power is not non-enforcement. It's misenforcement, suspension of the INA, or both. B. Alejandro N. Mayorkas created, reopened, or expanded a series of categorical parole programs never authorized by Congress for foreign nationals outside the United States, including for certain Central American minors, Ukrainians, Venezuelans, Cubans, Haitians, Nicaraguans, Colombians, Salvadorans, Guatemalans, and Hondurans, which enabled hundreds of thousands of inadmissible aliens to enter the United States in violation to the laws enacted by Congress. Alejandro N. Mayorkas willfully exceeded his release authority set forth in Section 236A of such act that permits, in certain circumstances, the release of aliens arrested on an administrative warrant, in that Alejandro N. Mayorkas released aliens arrested without a warrant despite their being subject to a separate applicable mandatory detention requirement set forth in Section 235B2 of such act. Alejandro N. Mayorkas released such aliens by retroactively issuing administrative warrants in an attempt to circumvent Section 235B2 of such act. In Florida versus the United States, number 321 CV 1066, Tango Kilo Whiskey, Zulu Charlie Bravo, Northern District of Florida, March 8, 2023, the United States District Court of the Northern District of Florida noted, and I quote, this sleight of hand using an arrest warrant as a de facto release warrant is administrative sophistry at its worst, end quote. In addition, the court concluded that, quote, what makes DHS's application of 236A in this manner unlawful is that 235B2, not 236A, governs the detention of applicants for admission whom DHS places in removal proceedings after inspection. Alejandro N. Mayorkas' willful and systemic refusal to comply with the law has had a calamitous consequence for the nation and the people of the United States, including one, during fiscal year 2017 through 2020, an average of about 590,000 aliens each fiscal year were encountered as inadmissible aliens at ports of entry on the southwest border or apprehended between ports of entry. Thereafter, during Alejandro N. Mayorkas' tenure in office, that number skyrocketed to over 1,400,000 in fiscal year 2021, over 2,300,000 in fiscal year 2022, and over 2,400,000 in fiscal year 2023. Similarly, during fiscal years 2017 through 2020, an average of 130,000 persons who were not turned back or apprehended after making an illegal entry were observed along the border each fiscal year. During Alejandro N. Mayorkas' tenure in office, that number more than trebled to 400,000 in fiscal year 2021, 600,000 in fiscal year 2022, 750,000 in fiscal year 2023. 2. American communities both along the southwest border and across the United States have been devastated by the dramatic growth in illegal entrants. The number of aliens unlawfully present and substantial rise in the number of aliens unlawfully granted parole, creating a fiscal and humanitarian crisis and dramatically degrading the quality of life of residents of those communities. For example, since 2022, more than 150,000 migrants have gone through New York City's shelter intake system. Indeed, the mayor of New York City has said that, quote, we are past our breaking point, end quote, and that, quote, this issue will destroy New York City, end quote. In fiscal year 2023, New York City spent $1 billion, $450 million, addressing Alejandro N. Mayorkas' migrant crisis, and city officials fear it will spend another $12 billion over the following 3 fiscal years, causing painful budget cuts to important city services. 3. Alejandro N. Mayorkas' unlawful mass release of apprehended aliens and unlawful mass grant of categorical parole to aliens have enticed an increasing number of aliens to make the dangerous journey to our southwest border. Consequently, according to the United Nations International Organization for Migration, the number of migrants intending to illegally cross our border who have perished along the way, either en route to the United States or at the border, almost doubled during the tenure of Alejandro N. Mayorkas as Secretary of Homeland Security, from an average of about 700 a year during the fiscal years 2017 through 2020 to an average of about 1,300 a year during fiscal year 2021 through 2023. Alien smuggling organizations have gained tremendous wealth during Alejandro N. Mayorkas' tenure as Secretary of Homeland Security, with their estimated revenues rising from about $500 million in 2018 to approximately $13 billion in 2022. During Alejandro N. Mayorkas' tenure as Secretary of Homeland Security, the immigration court backlog has more than doubled from about 1,300,000 cases to over 3 million cases. The exploding backlog is destroying the court's ability to administer justice and provide appropriate relief in a time frame that does not run into years or even decades. As Alejandro N. Mayorkas acknowledged, quote, "Those who have a valid claim to asylum often wait years for a decision. Likewise, non-citizens who will ultimately be found ineligible for asylum or other protection, which occurs in the majority of cases, often have spent many years in the United States prior to being ordered removed," end quote. He noted that of aliens placed in expedited removal proceedings and found to have a credible fear of persecution and thus referred to immigration judges for removal proceedings, quote, "significantly fewer than 20% were ultimately granted asylum," end quote. And only 28% of cases decided on their merits are grants of relief. Alejandro N. Mayorkas also admitted, quote, "The fact that migrants can wait in the United States for years before being issued a final order denying relief, and that many such individuals are never actually removed, likely incentivizes migrants to make the journey north," end quote. During Alejandro N. Mayorkas' tenure as Secretary of Homeland Security, approximately 450,000 unaccompanied alien children have been encountered at the southwest border, and the vast majority have been released into the United States. As a result, there has been a dramatic upsurge in migrant children being employed in dangerous and exploitive jobs in the United States.